Ladies and gentlemen, if we can get your attention, encourage you to find seats, and I'd like to welcome you to this session of the annual review. It promises to be a great session. To have both Hannah Smith and Jean Schaerr on the same program is something promising. First of all, I want to announce to those of you who are here for CLE credit, please pick up your CLE certificates at the registration desk. Now, I will not prolong interviews of Hannah and Jean because we want to give them as much time as possible. If you were just in this room, you saw Hannah on film, so that was a nice introduction. I don't think, Jean, do you have a film we can show? So I think not. But we're going to go in the order listed on the program. We'll hear first from Hannah and then from Jean, and we'll leave time for questions at the end. Thank you.
Thank you so much for being here. It's really wonderful for me to be here with you today. It's great to be back here in Provo, to be among friends, and I was just realizing today that it's been 15 years since we graduated from the law school here. So it's been an amazing weekend to be back here with you all in this great place. I want to first applaud you for being here today, for your interest in religious liberty, and for your interest in learning more about what you can do personally in your own communities to further religious freedom. And I appreciate that there are many in the audience today who are not lawyers, who have a specialty in something other than the law. So I have written this presentation such that it should be accessible to people who have been to law school, as well as to those of you who are very smart in something that I am not. So I hope that all of you will find something that you can glean from this presentation as we explore together today the Roberts Court and its jurisprudence with respect to religious freedom. We're a little over the 10-year mark since John Roberts became Chief Justice, and I thought it would be a good time to take stock of where we've come from, where we are, and where we are likely to go. There's a lot of gloom and doom sometimes when we talk about religious freedom, all of the threats that are out there, all of the things that could go wrong. And I hope that today my presentation will be more of an optimistic note to look at how many of these battles we have actually won, and all of the positive decisions that we have received from the Roberts Court over the last 10 years, and to let Jean have some time to talk about where we may be going in the future. I think that Jean and I agree that the Supreme Court has largely been protective of religious liberty in cases that don't involve abortion or sexual morality. I think the exception to that is probably in the Hobby Lobby and Little Sisters cases, which did involve contraceptives, and we did win those cases. So I think that's an exception to the general rule. But I think in those cases, I would refer you to Justice Sotomayor's comment during oral argument in Hobby Lobby when she said, "You choose your clients well." And I think that's a large measure as to why we succeeded in those cases, notwithstanding the valence of abortion and contraceptive rights. But if you look at the arc of religious freedom cases at the Supreme Court over the last 10 years, you will see that for the most part we have won virtually all of the battles to secure religious institutions and individuals their rights to live out their conscience without government intrusion. And I just want to show you quickly, 2006, Gonzalez via Centro. That was a RFRA case, a win, a 9-0 win. Hine, another win, limiting Establishment Clause standing. Salazar v. Buono, which involved a First Amendment Establishment Clause challenge to the Mojave Desert Cross. 2009, another government speech monument case was a win. 2011, another Establishment Clause tax credit case where the court held there was no standing to challenge it, a win for our side. Hosanna Tabor Lutheran Church and School, this was the ministerial exception case. Again, we won that case 9-0. That was a case that Becket Fund litigated. 2014, a 5-4 win in a RFRA case in Hobby Lobby. 2014, Town of Greece v. Galloway. This was a First Amendment Establishment Clause challenge to legislative prayer, and there we won again. Holt v. Hobbs. This was the religious beard case with a Muslim prisoner in Arkansas who challenged the Arkansas's grooming policy that did not permit him to wear a religious beard under the federal statute RLUIPA, and we won again in a 9-0 opinion. EEOC v. Abercrombie and Fitch. This was discussed a little bit earlier in the last section on employment rights and religious freedom. Again, a win for our side. 2015, Reed v. Town of Gilbert. This was a First Amendment speech case involving church signs. Again, we won that case. Zubik v. Burwell. This was the Little Sisters challenge to the HHS mandate, and I will talk about that more in depth later, but again, a significant victory there. So I'm highlighting these for you so you can see that relatively speaking, we've had more wins than losses. 12 victories with only 3 losses. That's an 80% average, which I think is a pretty good one over the last 10 years of the Roberts Court. So before we delve into more deeply some of the opinions of the Roberts Court, I want to give you a little bit of a background so that you can understand those decisions when we get to them in more depth. So let's talk about the lead up to the current law. Many of you have probably heard by now over the last 2 days about the important decision in Employment Division v. Smith in 1990. It's important to know what the legal standard was prior to 1990. So the Supreme Court applied the most stringent legal test known to constitutional law when there were burdens on religious exercise. The strict scrutiny test, which is what it's called, required that when a government action imposed a substantial burden on religious exercise, the government must show that it used the least restrictive means to forward its compelling interest. In 1990, that all changed. The Supreme Court decided Employment Division v. Smith, which held that there's no free exercise exemption from laws that are neutral and generally applicable. And this was an abandonment of the compelling governmental interest test and the least restrictive means test for free exercise claims under the First Amendment. So what happened in the wake of Smith? Congress passed 2 federal statutes to protect religious free exercise. The first was the Religious Freedom Restoration Act in 1993. This was back in an era when you had largely bipartisan support for religious freedom. So Senator Hatch and Senator Kennedy came together across the aisle to help push through RFRA in Congress, and there were only 3 dissenting votes from the federal RFRA. It passed with only 3 dissenting votes. And then secondly, in 2000, the Religious Land Use and Institutionalized Persons Act, which we're going to go into in more depth in just a little bit. So first of all, RFRA. RFRA prohibits the government from substantially burdening a person's exercise of religion, even if the burden results from a rule of general applicability, unless the government can demonstrate the burden is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling governmental interest. Now that should sound familiar to you, right? That's the test that existed under the First Amendment prior to Employment Division v. Smith. So what was Congress trying to do here? Congress was trying to restore that very stringent test for free exercise claims, but not under the First Amendment, this time under federal statute, because the Supreme Court had disavowed that test under the First Amendment in the Employment Division v. Smith case. So we had in 1997 the City of Bernie v. Flores case, where the Supreme Court struck down RFRA as it applied to the states. The Supreme Court said that Congress had exceeded its 14th Amendment Section 5 enforcement power to impose RFRA on the states. So now RFRA only applies to the federal government. This was a majority opinion actually authored by Kennedy, joined by Rehnquist, Stevens, Thomas, Ginsburg, Scalia joined in part. So you can see here that there were some conservative justices that were in the majority here striking down RFRA as it applied to the states. So in response to this, 21 states passed state RFRAs that largely mirror the federal RFRA. And in 2000, Congress, after 3 years of holding 9 hearings that documented state and local level burdens on religious exercise, passed the Religious Land Use and Institutionalized Persons Act. And this was in direct response to the Supreme Court striking down RFRA as it applied to the states in Bernie. Now, where did Congress focus in this federal statute? It focused narrowly on 2 areas, land use and prisons, where many disputes arise. And this federal statute, RLUIPA, in 2000, passed by unanimous consent and was signed into law by President Clinton. Again, a very different political climate back in the early to mid-late 90s than we have nowadays. So let's dive into some of the cases from the Roberts Court now that you have that background of what led us to Congress passing RFRA and RLUIPA. So first, in 2006, this was right after John Roberts was confirmed to be Chief Justice of the Supreme Court. It's the beginning of the Roberts Court era, and it's the first case that was decided under the Federal Religious Freedom Restoration Act. It's post-Bernie, and it's a case where there was a religious claimant that challenged the federal drug laws that did not provide an exemption for this religious group to use a hallucinogenic drug that they used in their sacrament for a sacramental use of ayahuasca. And this hallucinogen was banned by the federal drug laws, but the federal drug laws actually allowed an exemption for peyote for certain Native American use, but did not allow an exemption here. And Chief Justice Roberts, in his first opinion that he writes as Chief Justice of the court, writes a 9-0 opinion finding in favor of the religious claimants in that case. And the court held that the government had failed to show a compelling interest in barring this minority religious group's use of ayahuasca. And they found particularly compelling the fact that Congress had allowed this exemption for peyote. Now, fast forward a little bit to 2014, and we're going to talk about Burwell v. Hobby Lobby, which was a really important case for us at the Becket Fund because we had led the charge in mounting the litigation against the HHS mandate, both for religious nonprofits and also for family-owned businesses that had an objection to the HHS mandate. I think most of you know what the HHS mandate did. It required all employers to include in their health plans all FDA-approved contraceptives. This was problematic for some religious groups who had objections to Plan B and Ella, the morning after and week after pill that they viewed as abortifacients. There was a narrow exemption for churches, but it did not have any exemption for religious ministries, no exemption whatsoever for for-profit businesses or religious family-owned businesses. And if they didn't comply, they would be suffering debilitating fines that in many cases would put their religious ministries out of business. So despite the War on Women media campaign against Hobby Lobby, and despite the abortifacient overlay in this case, which, as I said at the beginning, usually dooms religious freedom cases at the Supreme Court. Despite all of that, the court held 5-4 in favor of Hobby Lobby. And there were 2 questions here. The first was whether for-profit corporations actually have religious liberty rights under RFRA. And Alito wrote the opinion for 5 justices on that threshold question, with only 2 in dissent, saying that yes, these closely held family-owned businesses were covered by RFRA. And then the next question was the merits question of whether or not there was a substantial burden to the exercise of religion here. And he said, surely if this isn't a substantial burden, what would be? Because of the debilitating fines that would be levied if the religious objectors did not include these services in their health plans. And then further, they went on to say, we don't have to decide whether the government had a compelling interest here. It's enough to say that there's an other way that they could accomplish that compelling governmental interest. That's another way of saying that this is not the least restrictive means of furthering its compelling governmental interest. And on that point, they said, look, the government could provide these services itself, or it could offer the so-called accommodation that it had created for the religious nonprofits to these for-profit businesses, and it hasn't done so yet. So those are two lesser restrictive means that it could have employed that it didn't, and so therefore it fails the compelling governmental interest test. There was a very vigorous dissent by Ginsburg, joined by Breyer and Sotomayor and Kagan, and that is how we ended that term. Hobby Lobby came down on the last day of that term. Now, moving on to the Little Sisters of the Poor, which is sort of the corollary to the Hobby Lobby case. Hobby Lobby involved for-profit family businesses. The Little Sisters of the Poor involved all of the religious ministries that challenged this HHS mandate. And again, the administration had argued that the not-for-profits weren't religious enough to qualify for an exemption. Remember at the beginning I had said that they exempted churches from the HHS mandate, but they didn't exempt any of the religious ministries. So they created this so-called accommodation, which was really no accommodation at all because it forced the Little Sisters and other religious ministries to sign a form that notified the government of their objection, but that form was not just notification, it was also an instrument to change their insurance plan, which would then give the government authority to use their insurance plan to effectuate the delivery of these drugs and services. So it was essentially hijacking their insurance plan and making them complicit in the delivery of these drugs and devices, which they couldn't abide. And so if they didn't comply, the Little Sisters would be subject to $70 million in fines, which of course would crush their ministry. This was a really unprecedented case in many ways, and in just one way I'll highlight right now, and that is that after oral argument, the Supreme Court issued a supplemental briefing order where it asked the parties whether the religious objectors could simply purchase a health plan without contraceptives, and then the government could provide the services even using the same insurance company, but through its own method, rather than hijacking the religious objectors' plan. And on May 16th, there was a unanimous order that came down, which was a three-part win for the religious objectors. First, the Supreme Court vacated all of the bad lower court's opinions that had found against the religious ministries. Many of those opinions had said that there was not a substantial burden on their religious exercise in this case, and those opinions would have been devastating not just for the religious ministries in these cases, but for future litigation under RFRA. Imagine a future litigant trying to distinguish that precedent when they bring their own claim about a different set of facts. So those precedents were all erased. They were vacated, and the court also said you can't levy these fines on the Little Sisters, so you can't enforce the $70 million of fines that they would be subject to if they didn't comply. And further, the court said, lower courts, you need to give the government time to work out an accommodation that is different than what they currently have, that actually does accommodate the religious objectors' beliefs here and does not burden them. So we felt like that was really a significant win for the Little Sisters. And again, I would just highlight here that if Justice Scalia had still been on the court in May when this decision came down, we would have likely had a full opinion on the merits, like Hobby Lobby. I think all of us were pretty confident after oral argument that that would have been the case if Justice Scalia had not passed. So again, just another way to highlight how Justice Scalia's passing significantly influenced and impacted the decisions of the court after his passing. I just want to highlight two more cases before I turn the time over to Jean. The Stormin v. Weissman case was a really important case that we had worked on with ADF over the years. In Washington, the State Board of Pharmacy initially supported a rule that protected conscience for pharmacy workers, and it permitted them, if they had a religious objection to dispensing abortifacient drugs, to refer customers to other pharmacies nearby. And there were other pharmacies nearby Stormin's pharmacy that were able to provide these drugs with no problem. So it wasn't an issue of actual access. And indeed, Washington had stipulated that there was no problem of access to these drugs at all. There was no evidence that anyone in the state had ever been unable to access these drugs because of a religious objection. But notwithstanding that, and under pressure from the Washington governor at the time and Planned Parenthood, the Board of Pharmacy reversed course, and they issued regulations that required pharmacists to stock and dispense drugs against their religious beliefs. These religious pharmacists and a family-owned pharmacy, Stormin, sued under the First Amendment. There's no Washington state RFRA, so this was a pure First Amendment claim. The district court initially held for the pharmacists on our side, but then the Ninth Circuit reversed, and so we filed a cert petition to the Supreme Court and asked them to take the case. Unfortunately, again, I think in large part because we were missing Justice Scalia on the court, we were not successful in getting cert granted in that case. The court denied cert last month, and there was a 15-page dissent written by Justice Alito that was joined by Chief Justice Roberts and Justice Thomas. So many of you know that there's a rule of 4 at the Supreme Court. If you can get 4 votes, you can get cert granted. Here we have 3 justices saying that cert should have been granted in this case, and if Justice Scalia were still alive, we would have had our 4th vote to review this case. It was a very passionate dissent by Justice Alito. He started off his dissent by saying, "This case is an ominous sign. If denial of cert here is a sign of how religious liberty claims will be treated in the years ahead, those who value religious freedom have cause for great concern." He thought that these regulations were clearly a violation of the First Amendment. This is what he wrote. "It seems to me likely that the board's regulations are not neutral and generally applicable. Quite the contrary. The evidence relied upon by the district court suggests that the regulations are targeted at religious conduct alone, to stamp out religiously motivated referrals while allowing referrals for secular reasons, whether by rule or by wink." And then finally, I just want to touch briefly on the case that is going to be heard by the court in the fall. So what can we look forward to when the court returns in October for its next term? Trinity Lutheran Church v. Pauley is a case that was granted by the court earlier this year. And it's a case where the state of Missouri established a scrap tire program to reduce tires in landfills and to improve children's safety on playgrounds. So they created this program where they would provide grants for qualifying organizations like schools, daycares, parks, nonprofits. And the grants would allow them to purchase material made from recycled tire bits. So the goal was to reduce the landfill and make playgrounds more safe for children. In 2012, Trinity Lutheran Church applied for this grant, and it was actually ranked 5th out of 44 applicants. And they actually ended up funding 14 of the projects. So it would have received the funds under a pure analysis of the criteria for these grants. But Missouri categorically excluded otherwise eligible religious organizations from a generally available public benefit that served wholly secular needs merely because of the organization's religious affiliation. It said, no, Trinity Lutheran, you don't get the grant because you are a religious school. And why did it do that? It did that because Missouri has a state constitutional provision that prohibits government aid to sectarian institutions. Now, in our book, sectarian's a bad word. Sectarian developed back in the days of the Blaine Amendments, and they are basically late 19th century anti-Catholic provisions that are in over 30 state different constitutions that prohibit state funds from going directly to churches or religious organizations. Now, there are 4 of the current U.S. Supreme Court justices, Kennedy, Thomas, Ginsburg, and Breyer, who have signed opinions previously that label Blaine amendments as anti-Catholic, and 2 of the justices, Thomas and Kennedy, have specifically noted that Blaine amendments were born of bigotry and should be buried now. But they still remain ensconced in these state constitutions, and they're still used to discriminate against religious groups. So in the fall, the court is going to decide whether excluding these religious groups from such state-created benefit programs violates the U.S. Constitution. And we filed an amicus brief in this case, and we said that basically the First Amendment requires neutrality, and it prevents the government from imposing special disabilities on the basis of religious views or religious status, and it requires the law not discriminate on its face. And here, this Missouri scrap tire program clearly does both. So it should not survive review. So I just want to make some final observations about the Roberts Court. This is my scorecard for the Roberts Court in the religious freedom jurisprudence. We've had 6 unanimous opinions: Ocentro, Pleasant Grove v. Sumum, Hosanna Tabor, Holt v. Hobbs, Reed v. Town of Gilbert, and Zubik v. Burwell. We've had one 8-1 opinion. That was the Abercrombie and Fitch case, and Thomas only dissented in part. So it's really basically unanimous. And then we only had 3 5-4 opinions. That was Hobby Lobby, Town of Greece, and the Wynn case, and 2 plurality opinions, and only 3 losses here. So just a couple of quick observations. I think it's fair to say that based on this track record, the Roberts Court has been largely protective of religious freedom. Again, when there are cases dealing with sexual morality or abortion, it gets a little bit more dicey. But we have seen in the RFRA and RLUIPA cases, Jean's going to talk a little bit more about the Holt v. Hobbs case, which was under RLUIPA, but clearly under the Hobby Lobby case and under Ocentro, both decisions under RFRA, the court has gone out of its way to show the breadth of these statutory protections. It has labeled them very broad, capacious, expansive protection. RFRA imposes a stringent test. It has called the least restrictive means test exceptionally demanding. So clearly the court, in its RFRA and RLUIPA opinions, has gone out of its way to say, notwithstanding our negative opinion in Employment Division v. Smith, which is not very helpful to religious claimants under the First Amendment, these federal statutes do provide very significant protection to religious claimants. Jean's going to talk a little bit more about Holt v. Hobbs and perhaps the impact of Obergefell on religious liberty going forward. And of course, I think we're going to have to wait to give any predictions about where the Roberts Court is going to go in the future until we know who's going to fill that last seat, who is going to take Justice Scalia's place. But I do want to end with an optimistic prediction, and that is that I think that we have been largely successful in protecting religious liberty, not only for individuals, but also for religious institutions through Hosanna Tabor, which was an Establishment Clause and free exercise case, as well as through our RFRA and RLUIPA cases in Holt and in Hobby Lobby and in Little Sisters, as well as in Ocentro. So I just want to hold out hope for all of you who have heard a lot of gloom and doom. There's a lot to be grateful for. There's a lot of reason to be optimistic, and I think that we are going to continue to see opportunities for us to win in the courts of law and at the Supreme Court in the future. Thank you.
I want to begin by thanking Hannah for that characteristically insightful and articulate presentation. Chief Justice Rehnquist once said of his colleagues on the Supreme Court that they are, quote, as independent as hogs on ice. And now for any reporters in the room, I'm going to emphasize that that is not my comparison, so put your pens down. I can just imagine the headline in the Tribune tomorrow, BYU law professor, justices are pigs. So don't write that. That's not me saying that. But Rehnquist Analogy is the key, I think, to answering the question that I've been asked to address today, which is, what will the new Supreme Court do about religious freedom? Chief Justice Rehnquist's analogy, as I mentioned, to hogs on ice is really the key to answering the question of where is the Supreme Court going to go? Where is the new Supreme Court going to go? And certainly that analogy was true of Justice Scalia, who was independent of everybody else in everything that he did in his life. But it also remains true that all the other justices are highly independent of each other. Now, many people often assume that the Supreme Court somehow thinks and acts as a single entity. That is, you sometimes hear people say, well, the court believes this, or that argument won't fly in the court, or whatever. But in fact, there is no unitary court. It's just a group of 9 individuals, each with his or her own views and inclinations and even prejudices on a whole range of issues that might affect their votes. So if you really want to predict how the court as a whole is going to rule on an issue, you have to do what the founding dean of the BYU Law School would often say, and that is you have to learn to count to 5. And that is, you have to carefully determine what each individual justice is likely to think about the issue at hand. And you do that by looking at everything that that justice has ever written, every opinion that he or she has ever joined, articles, speeches, life experiences, all of that. And you put it together, and you can usually come up with a pretty good prediction about how each justice is likely to vote in a particular case. And after you've done that, you can figure out how the court itself is likely to rule. So I'm going to focus on a somewhat narrower class of cases than Hannah discussed. That is, I'm going to focus just on cases in which the question the court is answering is, are we going to protect private, religiously motivated conduct? So I'm not going to talk about cases that involve expression on government property, like some of the cases that Hannah discussed, or things like the legislative prayer case, the town of Greece. I'm just going to focus on cases that involve private, religiously motivated conduct. And on those, as Hannah suggested, the court's record is pretty good. In fact, I'm going to go back to the Rehnquist court, and here's a list of the cases falling into that category that were decided from 1987 to 2005, which was the period of the Rehnquist court. There are 11 of them, and the court voted to protect religious liberty in 8 of those cases. Some of those cases involved the interpretation of the First Amendment, others involved the interpretation of federal statutes, but they all had that basic issue in common. Was the court going to protect religious conduct in one way or another? And so far, as Hannah mentioned, the Roberts Court has had 7 such cases and has voted to protect religious liberty in 6 of them. And I think the Zubik decision, or it's sometimes known as the Little Sisters of the Poor decision, was, even though it didn't result in a signed opinion, it was, I think, a tremendous victory for religious liberty, because it made clear that the Obama administration had overreached in its treatment of religious nonprofits. And so just summarizing the results here in the next slide, over this entire period, both the Rehnquist and the Roberts courts, there were a total of 18 cases that fall into that core religious liberty category, and the court ruled in favor of religious liberty almost 80% of the time. The Rehnquist court was a little lower than the average, 73%, and the Roberts court has been at 86%. And moreover, most of the justices have been pretty protective of religious liberty individually. Of course, they would have to be reasonably protective to produce those kinds of overall results. But before I show you a justice by justice analysis, let me just ask if are there any guesses as to which of the 4 justices who were left over from the, there we go. There's a picture of the Roberts Court as it existed last fall, and I assume most of you know who those justices are. Anybody want to take a guess as to which of the 4 justices left over from the Rehnquist Court were the least protective of religious liberty? You have Justice Thomas here on the left, then Justice Scalia, then Roberts, and Kennedy, and Ginsburg. Any guesses? Ginsburg, okay. Any idea who was the most protective in their votes? Sorry? Somebody said Thomas? Okay. Alito? But Alito wasn't there during the Rehnquist court. Actually, Justice Scalia was slightly more protective of religious liberty in his votes, despite the Smith decision, which of course was a big disaster. But in virtually all the other cases, he voted to protect religious liberty, including in cases under RFRA and Arlupa, which he had said in Smith would be a disaster if legislatures adopted those kinds of rules. He said in Smith that it would be madness for a legislature to adopt that kind of a broad rule and apply it to religious liberty. And yet, once Congress had done that in RFRA and Arlupa, he consistently voted to apply those statutes in a way that protected religious liberty. And so here's the scorecard for the 1989 to 2015 terms, and you can see there that of those who are still on the court, Justice Thomas has been the most protective of religious liberty among those who served in both courts. Roberts and Alito have voted to protect religious liberty in every single case that they've seen so far. And I think it's also interesting that the only justice that's below 50% is Justice Ginsburg. All the others are above 50%. Let's see. And then, and that, of course, means that the court rules in favor of religious liberty most of the time. Now, the court's 2015 decision in Holt versus Hobbs, which Hannah mentioned a little bit, is fairly typical of the decisions during this period. Yes, this is a picture of Mr. Holt, and the issue in that case was Mr. Holt was a prison inmate, and for religious reasons he wanted to wear a beard, and he said he would be satisfied with a half-inch beard, and so the prison wouldn't give him an exception to their no beard policy, and so he asserted a claim under our LUPA, which protects inmates in prisons throughout the country, asking for an exception. And in the Supreme Court, the prison claimed that even a half-inch beard might allow inmates to hide contraband or even weapons on their faces. And in a 9-0 decision, the court rejected that argument as implausible, and as a result held that the prison's insistence on applying the no-beard policy to Holt violated our LUPA. And so again, when you look at the voting patterns on the chart, it's easy to see that that result is pretty typical. That is, the Supreme Court usually votes to protect religiously motivated conduct, and usually by a pretty wide margin. Unfortunately, there's a big caveat to that conclusion, and Hannah alluded to it earlier, and that is when it comes to issues arising out of the sexual revolution that began in the 1960s, and I was actually alive then. And it was a revolution that continues to benefit us or haunt us today, depending on your perspective. And when it comes to cases that involve that complex of issues, the court is much less reliable in protecting religious freedom. And if we look again at the chart of Rehnquist court decisions, I've highlighted there the one sexual revolution-related decision, which is Dale versus Boy Scouts of America. And you remember that case. That was the case in which the court held that the Boy Scouts of America had a First Amendment right to decline to hire gay scoutmasters, notwithstanding a New Jersey law that otherwise would have forced them to not discriminate on the basis of sexual orientation. But it was as you can also see from the chart, it was a 5-4 decision, and so it was a decision that could easily have gone either way. And if you look at the other voting margins, though, you'll see that in the other cases where the court voted to uphold a religious freedom claim, it was generally by a very wide margin, 9-0, 8-1, that sort of thing. So if you, and then here's a similar chart for the Roberts Court. As you can see, the Roberts Court had 3 cases that raised sexual revolution kinds of issues. The one case in which the religious liberty claim was rejected was a case called CLS versus Martinez, which involved the ability of school-supported clubs to base leadership decisions on religious standards of, among other things, sexual morality. And the court held that the First Amendment did not protect, well, the court kind of played around with the issue that was presented there, but they ultimately held that the religious club's claim had to be rejected. But it was, again, it was a close decision. It was rejected by a vote of 5-4. But as Hannah mentioned, the religious liberty claim prevailed in Hobby Lobby, which involved contraception, and the religious liberty claim prevailed in the Little Sisters case, which also involved the contraception mandate of Obamacare. But here again, notice the voting margins. Other than Zubik, the margins in those cases are all 5-4. Now, the next slide here compares the overall voting records of each justice with his or her record in just the sexual revolution cases. And as you can see, Justices Thomas, Roberts, and Alito vote for religious liberty in both cases of in both categories of cases quite consistently. Justice Scalia did the same thing. He voted in favor of religious liberty in 100% of the sexual revolution cases that came before him. And Justice Kennedy's voting record in those two types of cases is also remarkably similar. He voted in favor of religious liberty 75% of the time in the sexual revolution kinds of cases, and 76% of time in all the cases across the board. So there's an interesting pattern among these justices. Anybody notice it? Between those who are less protective in sexual revolution kinds of cases. And yes, this is an election year, so it's fine to be political. That's right. The four who were less willing to vote to protect religious liberty in the sexual revolution kinds of cases were all appointed by Democratic presidents, two different Democratic presidents, but the four who were still on the court who had been more protective of religious liberty in those cases were all appointed by three different Republican presidents. And that, of course, leads me to the presidential election, which may or may not involve a contest between these two people. But just based on the prior slide, I think it's likely that a president of either party is likely to appoint someone who will generally vote to protect religious liberty in cases that don't involve a clash between the sexual revolution and religious liberty. I think that's pretty much a given. In fact, you can see that even more clearly from yet another slide that's a slightly different comparison. This is a comparison between the sexual revolution cases, which are in red, and all other cases. So the purple bars exclude the sexual revolution cases. And so you can see from looking at that chart that the Democratic appointees are pretty similar to the Republican appointees in cases that don't involve sexual revolution kinds of issues. It's only in the sexual revolution cases where there's really a statistically significant difference, with the exception of Justice Ginsburg. I think her voting record is definitely less protective of religious freedom even in the non-sexual revolution cases, but it's still 2/3, still well above 50%. So if we look now at the people that Donald Trump has indicated that he would consider appointing to the Supreme Court, and if we assume that he would follow his word, keep his word in his judicial selections if he were elected, it's a group of people that I'm quite confident would be quite protective of religious freedom in both kinds of cases. These are people who were carefully vetted by some pro-religious freedom groups in Washington, and three of them I know quite well who are personal friends. One of them is, of course, our own Justice Thomas Lee, who along with Justice Joan Larson from Michigan and Judge Bill Pryor from the 11th Circuit, any of the three of them would do a wonderful job on religious freedom if they were on the court. It seems equally, if not more likely, though, that a second President Clinton, would nominate judges who would probably give more weight to claims of sexual freedom when those claims conflict with claims of religious freedom. And so I think in terms of religious freedom, that's really the issue for the election. It's probably not religious freedom generally, but it's religious freedom when it conflicts with claims of sexual freedom. And of course, the problem is that at least in my view, the sexual revolution has become the greatest threat to religious liberty in the nation today, and so it's not a trivial issue. Now, besides distinguishing between sexual revolution and non-sexual revolution cases, I think it's useful to distinguish between cases decided under a statute and those decided under the First Amendment. Last year's decision. Yep, I've got some missing slides. I don't know what happened to them. Anyway, last year's decision in Abercrombie is a good example of cases involving religious freedom claims under a federal statute. And as you recall, it involved the religious accommodation requirement in Title VII, which requires all but the smallest public and private employers to accommodate their employees' religious needs, as long as that accommodation doesn't impose what the statute calls an undue hardship on the employer. Well, by way of background, the Supreme Court's first interpretation of that statute occurred in 1977, shortly after it was passed, and was, in my view, unfair in the way it construed the statute. It was a case, it was decided by the Berger Court, a group of people who were generally pro-business, Republicans and Democrats. And the case arose out of a lawsuit filed against TWA Airlines. I don't know if anybody remembers TWA Airlines. They're now part of American Airlines. But anyway, it was a private employer, and one of their employees sought a religious accommodation. He wanted, as I recall, he wanted to be able to not have to work on Sundays or on Saturdays because he was what we call a Sabbatarian. And so he told them he wanted Saturdays off for religious purposes. They wouldn't give it to him. And the Supreme Court ultimately sustained the employer's argument that anything more than what the court called a de minimis burden on the business was enough to satisfy the undue burden defense. So the court took the word undue and converted it into anything more than de minimis, which I think was just not a fair interpretation of the statutory language, but the effect of that was to significantly cut back the scope of religious freedom that statute provided. But last year, in the Abercrombie case, the court, in an opinion written by Justice Scalia, also a pretty pro-business Republican, took a very different approach to that same statute. The case involved a Muslim woman who was denied a job at Abercrombie Fitch because she wore a headscarf to her interview. And so they assumed, based on that she was a Muslim. She never told them that she needed an exception to the Abercrombie policy prohibiting headgear. They had a policy that said you can't wear headscarves if you're going to work here at Abercrombie. She never actually told them that she would need an exception or an accommodation from that requirement, but they looked at her and they just assumed that they would probably be asked for an accommodation if she worked there, and there was a clear record created that they were going to hire her before somebody in management said, "Oh, we don't want to deal with this potential religious freedom problem." And the Supreme Court sustained her claim after the Court of Appeals for the Tenth Circuit rejected her claim. The Tenth Circuit said, in order to make out a case under this provision of Title VII, the employee has to show that the employer had actual knowledge of a conflict between one of their work requirements and a religious requirement, and the employee had to show that he or she was refused employment because of that conflict, and the court held, well, no, actual knowledge isn't necessary, and a concern about a religious accommodation need only be a motivating factor in order for the employer to be liable under the statute. And in my view, that was a very fair reading of the statutory language and its history, in contrast to the court's earlier decision in TWA versus Hardison, where they, in my view, unfairly restricted the scope of the statute. And here again, Abercrombie reflects a common pattern in both the Rehnquist courts and even more so in the Roberts court, which is that. Well, let me pull up the list. You can see here. Okay. You can see here that in the Roberts Court, of the 7 religious liberty decisions, you'll see that only 2 of them were decided under the First Amendment, CLS versus Martinez, which we discussed, and Hosanna Tabor, which I'm sure you're all familiar with, which held that the First Amendment requires a ministerial exemption so that the state can't dictate to religious bodies whom they have to hire as their ministers or keep them as their ministers. And so of the 2 First Amendment cases, the religious liberty claim prevailed in one and failed in the other. but in all 5 of the statutory cases, the religious liberty claim prevailed. And that included 2 cases that, again, involved the sexual revolution. So the message here, I think, is that the justices are much more comfortable protecting religious freedom under a statute than under the Constitution. And you might ask, well, why would that be? I mean, obviously the court is, in other contexts, isn't shy about overturning government action based on the Constitution. But I think the answer is that the court, even though the court is not shy about using the Constitution to overturn things like marriage laws and the like, they're still sensitive to their status as a non-elected body. And so members of the court see invalidation of government action based on the Constitution as much more undemocratic than overturning government action based on a statute that was passed recently by an elected body, which of course is true of both RFRA and ARLUPA. And unlike the trap the court sometimes falls into in interpreting the Constitution, the court today is more likely to enforce federal statutes fairly according to their terms, and that's one of the little noticed victories that Justice Scalia won during his career on the court. He didn't win the victory over originalism or originalist interpretation when it comes to the Constitution, but when it comes to interpreting statutes, the Supreme Court and most other courts in the country are very different now in their approach to statutes than they were before Justice Scalia came on the scene, where in interpreting statutes, they would routinely sort of, as in TWA versus Hardison, courts would very often just sort of mold the statute to fit their own view of what was of what was good and what made sense, and that's much more rare today on the Supreme Court than it was before. And I submit that all of this is generally true of state Supreme Courts as well. State Supreme Courts also are generally more comfortable telling a governmental body that they can't do something they want to do if they can tell them that based on a state statute rather than on a federal or state constitution. And so to me, this conclusion highlights what I think is one of the most important conclusions that we can draw out of all of this, which is the need for clear legislation wherever possible addressing predictable religious freedom disputes. And I think the Utah Compromise was a very good example of that. Those who drafted that legislation obviously realized that if you extend non-discrimination standards based on sexual orientation and gender identity, that would create a host of religious freedom issues for both religious institutions and individuals, especially here in Utah. So the legislature did its best to anticipate and address those issues, and as a result, when religious freedom conflicts arise, the courts will generally know how to deal with them, and they'll feel much more comfortable sustaining the religious liberty claim and rejecting the sexual freedom claim, which is what the clash is likely to be. They'll feel more comfortable sustaining the religious liberty claim because they'll feel like they're simply enforcing the will of the people and the contemporaneous will of the people rather than poking their finger in the public eye. And so just to conclude and to come back to our basic question here, still not working right, but remember the question we started with is what will the new Supreme Court do about religious liberty? In the short run, they will probably do more of the same, regardless of who is appointed to replace Justice Scalia. Except in cases involving the sexual revolution, the Supreme Court will generally be more favorable to religious freedom claims. But in cases that do involve the sexual revolution, it's clear that we cannot rely upon the Supreme Court to save our bacon if we're concerned about religious freedom. Yes, the court will lean more towards protecting religious liberty, even in the face of sexual freedom claims, if a Republican is elected, in all likelihood, and will lean more in favor of protecting sexual freedom claims over religious liberty if a Democrat is elected in the fall. That's just based on the last 30 years of history. But in all cases, if the court is asked to apply a statute rather than the Constitution, it's likely to give the statute a fair reading that protects religious liberty rather than manipulating it into something that is less protective of religious liberty than its drafters intended. And that's why, in my judgment, it's important to all of us who value religious liberty to do our best, wherever possible, to protect that liberty through sensible and clearly crafted statutes, and even if it means compromising with those of different views. So I look forward to your questions.
It's pretty rare for us to get two people on the same panel with such exceptional resumes. And I promise we did not intentionally sabotage Gene's slides to show you how well they operate under pressure, but we got to see a little of that with both of them. But regardless, I'm going to exercise some prerogative. Say we're going to take 5 minutes for questions, maybe 2 questions. And I happen to know intimately one of the persons on the next panel won't mind this at all. So questions, please. We'll start right here with Dwayne.
Gene, do you think there are any particular
Use the mic, please.
any particular statutes that have been passed recently that are strongly defensive of religious freedom, please?
I think the Utah Compromise was a model. Yeah, I really do. Now, a lot of people complain about the fact that the Utah Compromise didn't include express protections for people who provide wedding services, but that's really a non-issue in Utah because there's no public accommodation statute in Utah that would ordinarily require them to provide wedding services to people when they don't want to provide those services. So most people cite that as the big gap in the Utah Compromise. I think that's an unfair criticism, and for reasons that Tim Schultz explained very well yesterday, the Utah Compromise in numerous areas protected the interests not just of religious institutions, which was important to protect, but also the interests of individuals.
One more? Yes, sir.
What would you think would happen if the Democrats win the election and the Republicans decided to confirm the current nominee for the Supreme Court? Have you got an opinion on that?
I don't know him very well. My experience with him suggests that he's a very good, solid judge. But I think for anybody appointed by a Democratic president, knowing the importance of the LGBT community to the Democratic coalition is going to feel heavily pulled to give a lot of weight to claims asserted by that community. So I suspect if Judge Garland is elevated to the Supreme Court, that he will probably fall more into the camp of justices who tend to give more weight to claims of sexual freedom than claims of religious freedom. But I don't know him well enough to know that for sure, and I've read everything he's written about religious freedom, and there's just nothing in his record that would suggest an answer one way or another.
I think we'll conclude there, and once again, let's thank Gene Schaerr and Hannah Smith.